Okay, we are here live with Eric Johnson of Utah Family Law TV. This video is titled Reversed and Remanded. And why don't you start off with the introduction, and not just of yourself, but perhaps of your recent appellate victory. Go ahead, Eric.
Yeah, so Utah Family Law TV is not associated with my practice. So I'm a divorce and family lawyer in Utah, but I created Utah Family Law TV as a public service to help people get greater access to the public court proceedings, specifically those in domestic relations, divorce and family law cases. It is and remains an uphill battle. That's how I came to meet Alex, because he's had his own battles trying to do that for the state of Nevada. And so we're going to talk on both of our respective channels. For those of you that have watched his, he'll talk about what goes on in Nevada courts, various domestic relations or domestic relations related stuff in the Nevada courts. And I try to do the same in Utah, and have not been nearly as successful to this point as Alex is at this point with his channel. And so I have a great deal of admiration and respect for the effort and the courage it has taken. Now, I don't have to say that to get on Alex's program. I just really mean that. And so I'm very proud of him, because I know what he's going through probably better than a lot of people do, simply because we do something similar. Yeah. But we're going to talk about me only because I filed an appeal for a client of mine who I have to give props to, because he's the one that had to put up the money, and he's the one that had to take the risk. And I just did the argumentation side of things, and I have to give credit to the people that worked with me, because it was the first appeal I had ever filed. So I'm very happy to have filed an appeal and won on the first go-round.
Oh, wow.
And not only that, but this is one of those rare situations where when you win, it's good to say it's been the Court of Appeals has found you to be the winner, and then reverses the trial court and remands it, sends it back to the trial court to be redecided in conformity with what the Court of Appeals said. But it's very rare when the Court of Appeals or the Utah Supreme Court, in this case it's the Utah Court of Appeals, reversed and said, we're not going to give the trial court a chance to do this again. We're going to order the court to award joint equal physical custody to a father. And that is rare.
Just a few responses here. Josh Swolinkovich says, hello, Eric. And Karen McNaughton says that she loves both our channels. I do want to mention that I have a few years head start on you. I was pretty much where you were at this point in time. And I remember other YouTubers with bigger channels helping me get as far as I could. And I now get to sort of pay it forward. And it's not just to be nice. You're also competent. You speak the truth even when it's not popular, especially rare when it comes to family law attorneys. And so that's a huge breath of fresh air. And yeah, you didn't just get a remand, which is one of the huge things that people have anxiety about here in Nevada. This is, okay, I win my appeal, it remands, and then the judge just finds another way to screw me over, or at least that's a sentiment that they have. You got,
that's the fear.
Right, you actually got an order from the Court of Appeals saying this person is to have joint physical custody. How did you do that?
I'm not exactly sure myself, because again, this is the first appeal I had filed. I've seen a family law case. I've helped with other appellate briefs in other areas, but essentially, if you look at what the Court of Appeals said, it was that the court had the trial court had made findings that the father in this case had done everything you could reasonably expect of this father, and had placed himself in a position, every reasonable position you could expect, to exercise joint physical custody. There had been nothing found wrong with him, nothing to make him unfit to exercise joint physical custody. And so it was an interesting situation. Without any disrespect for the trial court, I agree with the Court of Appeals in that the trial court made the requisite findings to support an award of joint equal physical custody. And then its decision not to award joint equal physical custody just wasn't consistent with the facts. And it was so clear on the record that the Court of Appeals felt that it could make that direction to the court, ordering the trial court to award joint equal custody.
I notice here, and I'm going to go ahead and read it. I've got the order up. Here's a brief summary just for the viewers. We conclude that the court exceeded its discretion in not dividing parenting time equally between the parties. We also conclude that the court erred in its personal property determination and that its attorney fee award was not supported by sufficient findings. Does Utah have the same strict statutes controlling how attorney fees are awarded? Because Nevada does, and that's one of the things that are much more likely to be reversed because of the fact that there are strict limitations as to how these judges can award attorney fees.
Well, and again, I've been in practice for 24 years, and I've wanted to file appeals in the past, but I've either been in a situation where I felt the client was not treated fairly at the trial level, but I also felt that it was within the discretion of the trial court, so that if we did appeal it, we would lose on appeal because I was afraid the Court of Appeals would find that the court did not abuse its discretion. And I mean, our Court of Appeals does a good job, I think, of articulating its decisions more often than not. And they will say sometimes, we may not have reached the same decision as this trial judge did, but that's not our job. It's not to second guess the trial court, but did the judge exceed his or her discretion? And while we find this decision of the trial court to be kind of hard to follow, we could follow it, so we're not going to reverse. In this case, they said we follow exactly what the trial court did, and it leaves nothing to the imagination. This was an abuse of its discretion, and it shouldn't have done what it did. So that's what happened there. Can I touch briefly on the other things?
Definitely.
So we appealed custody. That was the main reason. That was something where it's like any parent is heartbroken when they are relegated to less than equal time with their children when they're capable of exercising it, and that was the main thing for here. And that's the thing that I come away with very just overjoyed with, and grateful that there's now this additional case law that I hope will help other parents, particularly fathers, because they're the ones that have the uphill battle. But also, there were gifts of jewelry from the husband to the wife during the marriage that the court mistakenly treated as, well, if a husband gives his wife gifts during the marriage, they are not marital property, they are her separate property, which just isn't true in the state of Utah. So we got that reversed and remanded. And then there was the question of attorney's fees, which was, in this case, the wife had the money to pay her own fees and paid her own fees, but somehow the court awarded her attorney's fees anyway.
Yeah.
So that was reversed and remanded.
We have that happen here a lot, and it reverses over and over again, and I'm like, are you guys not reading? So I just now noticed that you were published. So what does it feel like to do your one appeal, your first appeal? Not only do you win, but then you're published. I didn't even notice that. That's great.
This is going to, it's funny. It's going to sound like a humble brag, right? I don't seek the limelight, but I'm happy to be in the limelight if it brings to the attention of the system and judges and the appellate court some of the problems that need to be better handled. So I'm not proud of myself. I'm proud of my client for having the guts and the faith to appeal. And I'm grateful that we have what I think to be an extremely well-reasoned decision, because it's the right thing to do, and it's going to help more fit parents seeking joint custody. It's going to make it that much easier for them. That's what I'm happy about.
Yeah, this is probably going to be used a lot.
And I'd be lying if I didn't think it's cool that I have a published opinion. But I mean, that wasn't what I was going.
It does feel good. I mean, I've said it before. People have asked me, and I'm like, it's one thing to beat your ex. It's another thing to beat the judge. And even though that's not the way that it's supposed to be, but sometimes in family court, it does feel like the judge becomes the adversary. There's even an attorney here in Nevada that was actually looking forward to watch this. She's a family law attorney, and she's just been I don't know what the word is, demoralized by the family court rulings that she's getting. And she was like, I'm going to come watch the Eric Johnson live stream because I need to learn how this works. And that's what you're doing, is you're not just inspiring parents, even though, I mean, this does inspire parents. You're also inspiring some of your colleagues, even if they're not in the same state. Over here, they want to watch and see how this can work, because it just feels like there's just no way to win family court appeals to some of the attorneys, even though it's not true.
And I will say this. Yeah, I will say this. I mean, I had a client who had the means to afford to do it.
Mm-hmm.
I was willing to give him a bargain price because I believed so much in his cause and in the cause generally. So that made it all possible.
Yeah.
And so if I were to work on something next, it would be trying to figure out a way to create some kind of form bank and argument bank and brief bank to make it so that people with worthwhile appellate causes can file them and brief them without having to spend $20,000 to $30,000 on it.
You know that I've talked about this before you came on my channel. It's a really big deal when you do the appeal for your own client, because then an appellate counsel is going to have to look over everything. You were there. So it's cheaper for you because, I mean, you still have to review, but you remember you were the trial lawyer. So when you do the appeal, it's such a huge service for your client. You save them so much money than if they have to go find somebody else. And I wish more family law attorneys would do this, because it's like the only way it's even close to within reach for a lot of these family court litigants. A lot of them don't have the $20,000 or $25,000 to find a dedicated appellate attorney. So definitely that's a huge thing. I used to tell people, if I was going to hire a lawyer, that's the kind of lawyer I would hire, is one that could do the appeal if something went wrong. Some attorneys, this is not some litigants, some attorneys in Nevada have told me they are afraid to appeal a family court judge's decision. Did you have that sort of fear? And if so, why?
Have you ever heard the phrase saying thanks for everything really means thanks for nothing because you haven't specified? And I feel this. In other words, I'm not afraid of anything because I'm afraid of everything.
Okay.
You know what I mean? I mean, I don't hate any district court judge here in Utah. I don't hate any commissioner here in Utah, but there are some that I think are incompetent. I'm not going to name names, but I mean, but it's nothing personal.
Yeah.
So the one thing I have to do a gut check every time I ever think I'm going to tell this judge or this commissioner that's wrong, that that's not the correct statute. You've interpreted it wrong, or it's like you've overlooked this fact. I understand that I was a small claims judge, so I know something from which I'm speaking, is that if somebody pointed out a mistake that I made, I don't lie. I mean, I'm as vain and proud as any other normal, red-blooded man. But I had to then use my intelligence to say, this isn't about you, Eric. You did make a mistake. Now humbly acknowledge it and make the right decision. And do justice. And what gets me is that that's not that hard. And so if you're worried about looking foolish, one sure way to look foolish is to double down and not admit your mistakes and fix them. And so those are the kinds of judges anywhere, Utah or anywhere, at the state, federal level. So I wish that there were more judges that realized, hey, you can't possibly know everything. There's too much law on the books. You can't be an expert in everything. And even if you're very well read, you can still be tired, or you can be distracted by, your spouse's cancer treatment, and you're going to make mistakes. When you make a mistake, please have the humility to correct it. When you make a mistake, or when you realize that your thinking is flawed, change it, and don't feel bad that it's like, well, gee, all these other people I treated this way. It's like, you're only human. But the last thing you should do is say, well, I've been doing this for so long, it's better to be consistent than to do what's correct.
By the way, we have a family law attorney who's watching you live, and she says, Monica Cafferati says, hi, congratulations, Eric. She's actually going to be on one of our panel discussions in our Nevada Judges channel. I'm hoping to maybe get you and Monica Cafferati on that channel sometime soon in the future. I like to just kind of add to what you said is I feel like most judges are, going to do the right thing, and they're going to, respond with humility. And I have an example of one who didn't. In fact, the Supreme Court lambasted the judge. I won't name the judge. The judge was overturned on appeal. They sent it back, and then on remand, she messed up again, and so they reversed again. But the second time, they said that she capriciously she made a capricious ruling because she was upset about the prior remand, and they really let her have it. That like they were like, that's not how this works. This is manifest. This is capricious and stuff like that. And that wasn't even a family court judge, so that kind of surprised me. But yeah, it's a valid concern. I think that does happen sometimes, and I think that a lot of attorneys wouldn't have told me that if they didn't feel it.
Okay, and this is the thing, Your Honors, wherever you may be, I understand it's a thankless job.
Yeah.
But that doesn't mean you get to make your own rules.
Yeah.
It doesn't mean that you get to do what you want to do to make it bearable. If you can't do the job the way it's required to be done, and to do it in a way that results in just outcomes, so that, yes, sometimes people you sympathize with who deserve to lose, and sometimes friends that you hate to see lose, and sometimes SOBs win because technically they comply. I as a small claims judge, I saw that there were people that I didn't like personally, but I wasn't king, and it wasn't a popularity contest. And so, an example was these check cashing businesses, or these payday loan places, where they have 500% interest and stuff like that. And that my heart went out to some of these people. But the fact is that the laws on the books allowed the plaintiffs to sue these people and get these monster judgments for $5,000 for a $300 loan. And I would say, it's like, I don't like what I'm about to do, but the law is clear. Plaintiff wins. We need more judges that are saying, my job is, like Justice Roberts said when he was being vetted for the Supreme Court, balls and strikes. Sometimes you do have to make some judgment decisions. Sometimes the facts don't point where you have to go. And you really do have to pick the winner and the loser. And even then, you should be saying, what principles guide me, as opposed to how I personally feel.
Yeah.
That's a problem.
I love YouTube. I feel like it gives attorneys like you a chance to connect with the public in ways that otherwise wouldn't be possible.
And to make more enemies in the legal profession.
Yeah.
Because they speak their minds. And I really hope people don't hold that against me, because I love the fact that we can share our honest opinions, and that doesn't mean that I'm tearing down civilization, as I know.
There's this. I think it's going to get better over there. It was like this over here for a long time, and there's just takes a huge push of attorneys like you to just stay on top of it, and maybe more of them will crop up, and would just be relentless. And Eric Johnson. So I'm going to let you guys know Eric doesn't have a lot of time. He's got to go soon. You have one question from one of the viewers.
Sure.
I don't know if you can answer this one. All right, I'm going to ask it, Kodomo, but don't be surprised if you can't answer it. The question is, Eric, what do you think of Judge Hanson? I don't know who he's talking about.
I don't know Judge Hanson well enough to have an opinion.
Okay.
And even if I did have an opinion of any particular judge, I'm not going to do that.
Yeah, that's a no comment right there, guys. Well, I would have expected that.
Well, let me tell you why. It's not because I'm afraid of that, although I am afraid to give honest opinions. It's too bad. We should be able to offer honest opinions without without slandering or libeling somebody. If we were to say, I don't like this, or I do like that, but I'm not going to do that simply because that's not fair to somebody. Fortunately, I can't give you an honest opinion of Judge Hanson because I don't know him. I've only appeared in front of him once, to my knowledge.
That makes me think this must be a viewer from your channel, because I don't know who this is, but I don't know the judge's name, so it's a Utah judge. But yeah, guys, commenting on, like, it's just pure opinion, and it's like more harm than good can come from it, especially working within the legal system. So
yeah, and I don't want to be unkind.
I
don't even want to be perceived to be unkind. Now, by the way, is that because am I telegraphing, or am I implying that I don't like Judge Hanson? No, what I'm saying is, no, I can honestly tell you, check the records. I think I've appeared in front of Judge Hanson once in my career. I simply can't, and it was only for like some kind of conference. It wasn't a full-blown trial or hearing. I just don't have an opinion.
The viewer just said that they appreciate you and that it's no problem at all. Guys, I'm gonna do one comment, one question, and then let him get going because he doesn't have a lot of time. So Joshua has a comment, and he says, "Thank you for sharing, Eric. Please provide the published case." I'll go ahead and provide the link, Josh, in the description of this video so that you can read his publication. And then Karen, last question to you. Karen McNaughton says, "Do you think it is fair that family court judges have so much discretion?" Good question.
No.
I don't.
Excellent
I,
answer.
I think that we need to have some changes to the rules
Yeah.
and to the statute
Yeah.
to set some standards that narrow the discretion to prevent some of the miscarriages of justice we see, precisely because there is so much discretion. I don't claim to know how to do that.
Mm-hmm.
I'm not on any kind of panel or blue ribbon commission to do that, but I would hope that we could either find a way to do it by rule,
Mm-hmm.
or simply create some canons or some principles that help to make it so that judges can say, well, don't blame me, I'm simply following the rules.
Right.
And as long as those rules end up being an improvement over what we have.
Right. So no more questions. You're getting a lot, but guys, we'll come back another day with Eric Johnson, maybe when he wins his next appeal. Thank you for coming on, Eric. If you guys want to support him, he's in his attorney capacity, so I'll stop because he's very professional. He doesn't want to merge his attorney capacity with his other channel. So that's enough, guys. Thank you for coming on. Thanks for coming on, Eric. As always, it's a pleasure. Have a great day.
Thanks for having me here.